don't know me, my name is Lauren Goldberg, and I'm a principal at the Abington Page. And I've been there since 2000. And before that, I was lead counsel to the State Selectmen Division, and I also served as an attorney in the Public Records Division. Yes. Oh, I can come over there. That's fine. So, although I purported to be technologically prepared for you today, it appears I only sent one of the PowerPoints that I was going to use. So, we're going to have to, let me just use a different format, and I apologize for not having that. Okay. All right. So, as you know, and I'm not sure how many of you are on boards and committees. Maybe that's a good place to start. You want to just quickly tell me which committees you're from, just so I have an idea of who's here. Shout it out.
Finance
Library trustees.
Okay.
Board of Health.
Excellent. Okay. All right. So, okay, great. So we have some formal committees that meet a lot and some that might not meet as much. Any committee that's any public body under the open meeting law, and a public body is a body that, however elected, appointed, whether paid or unpaid, that's a multiple member body, is going to be considered a, and John, we can actually turn that off for now because we're going to switch to that after. It's considered a body that's subject to the open meeting law. And basically, if you're a body that's subject to the open meeting law, you're required to post your meetings. That's the first and most important thing. Now, the posting of meetings under the new open meeting law differs significantly from posting of meetings under the old open meeting law. I used to start off with a list of myths, and I would say, what's true and what's false about the open meeting law? You know, is it true that you need to post an agenda? And people would raise their hands and say, of course you need to post an agenda. Everyone needs an agenda. But under the old open meeting law, there was no agenda requirement at all. So there was no requirement that you do anything aside from post the time, date, and place of your meeting. The new law, however, is quite different, and it requires that there be a list of the matters that the chairman of the board reasonably anticipates will be discussed at the meeting. Now, the term reasonably anticipate is not a term that is defined under the law. So the Attorney General, who's the entity under the new law who has authority to enforce it, has been interpreting it frequently through written decisions. For those of you who have not yet visited the Attorney General's website, they have a very comprehensive website with an open meeting law guide, as well as a listing of decisions that have been issued by that entity since the law was passed. And it has a whole section on, as I said, on these decisions. And if you want to, you could read through each one, and you'll find in reading through each one that there is guidance, basically. But it's not a one-liner. It's not like you can open it and look at it. You have to read through each decision. The short form of what the Attorney General is requiring is essentially a detailed list of what's going to be considered. So it's not enough to simply say executive session. You need to say executive session and the purpose that you're going in for, like you normally would have, as well as the name of the person you're going to discuss, if you're going to be discussing a person in executive session, or if you're going to be discussing a case in executive session and it wouldn't affect the outcome of the discussion, the outcome of the case, to identify the case, then you identify the case. If you're going to be doing bargaining with non-union personnel and you're going to have them present, you're supposed to put the name of the individual straight into the agenda or into the notice that's going to be posted. Now, we have seen the most objections filed with the Attorney General's office about this issue. Does the notice provide enough specificity to allow a board to act? So you are smart to include more rather than less to avoid a challenge as to your agenda, but you also need to keep in mind that if you put in a lot about a lot of things and then you don't put in a lot about another thing, that someone might say, well, that item isn't specific enough and everything else is so specific. You shouldn't have talked about that. So you want to try to find a nice medium where you're putting in enough information to give notice, but not so much that you limit yourselves. And if it sounds like a lawyer is speaking right now, I blame that on the drafters of the law, because we're trying to help you to interpret it, but it is not easy. One example of what we've seen is for soil permits in a town. It's actually in the town of Freetown. There was a decision where the AG said just putting on the agenda fall soil permit renewals was not specific enough. And they said if you knew which soil permits were going to be decided by the board, if you had applications in front of you, you need to list them all, including the address and the person's name, the applicant's name. So this raises issues for boards with respect to appointments, because you're supposed to list every single appointment you're going to make, and the answer is maybe. But certainly for land use boards, if you have hearings that are going to be held, you want to put down the name of the applicant and the address. If you are the Board of Health, same thing. And the more specific information, the better, basically. Except when it comes to litigation. And the litigation example that I gave earlier is something you really need to think about. Does it make sense to mention the case name, or could mentioning the case name affect the litigation itself? And sometimes just mentioning it would tip off the other side that you're thinking about something. I'll give you another example, and I'm sure this is one that you all are going to find interesting, and that is that the Natick School Committee had some articles on the town meeting warrant for an annual meeting, which makes perfect sense. And on the agenda, it said superintendent's update, town meeting update. And so they discussed several warrant articles and voted to make recommendations to town meeting. And the AG found that that wasn't a specific enough notice. And interestingly enough, the complaint didn't even address that, and they addressed it on their own in the letter that they sent, the enforcement letter. And they said that notice should have said, Superintendent's update. Consider Articles 1, 3, 9, 7, and 15 of the fall annual town meeting warrant. School committee may make recommendations concerning Articles for town meeting. That's a whole lot. That's a huge change from what we're used to. And it's difficult because it's hard to anticipate every single thing a board might talk about. I have had discussions with the AG's office where I've suggested that, it's if that's the level of specificity that's required, it's very difficult for a board to do any business, because there are often times when things related to things on the warrant on an agenda are going to come up, and does that mean the board's not supposed to talk about them? The board's position the AG's position on that is, if you had no reason to know, if the chairman had no reason to anticipate that something was going to come up. So, for example, someone in the crowd raises it during a public participation period, or a single selectman raises it other than the chairman, or a single member of the school committee raises an issue that's been important to him or her without having first notified the chairman, then that issue, by law, may be discussed at the meeting. But the AG's office has actually put in writing that it recommends that it be put off to a later meeting if possible. So that's not a legal requirement. And in my opinion, under the law, that a board can talk about anything that it did not reasonably anticipate if it wants to at that meeting, and can vote on it. Okay? So, agendas. So, in answer to the question, is it required that there be an agenda? There's a requirement that there be a notice, and it states in the law that a list of topics is required that the chairman reasonably anticipates. However, the AG has been interpreting that as a list of the items that will actually be discussed and voted on. Now, just in case you feel like you should be taking frantic notes and you don't want to, I will send the right PowerPoint over to John later, and so you'll have this information already, so you don't need to feel stressed about that, which is why I like to give you the PowerPoint and the outline ahead of time. But You'll forgive me. Okay, so that's the agenda. Now, a public body, the public body definition has changed a bit. It used to say a public body of the town, and now it says a public body from the town. So my inclination was that the AG might interpret that more restrictively. So, for example, if John is authorized by charter or special act or a bylaw to do something on his own, and he appoints a committee, okay, that committee is not subject to the open meeting law under the old definition of public body, of governmental body. And so my concern was this of and from business would change the AG's perception of what constituted a public body, but they have taken the position that the old case law continues to apply. So if a single individual, like a superintendent or the town clerk, has authority under law to do something on his or her own, and they appoint a committee to help them with that, that is not a public body. In contrast, if the Board of Selectmen or the school committee or the finance committee appoints a committee to do work for it, then that committee is viewed as a subcommittee and it is subject to the open meeting law. You get the distinction. If a single person with authority to take action on his or her own appoints a committee, no open meeting law. But if a committee appoints a committee, it's subject to the open meeting law. Okay? A single individual is not subject to the open meeting law. So let's say if I'm a member Board of Selectmen and they say, Selectman X, we would like you to do X, Y, and Z, that individual is not subject to the open meeting law when they're doing X, Y, and Z. However, as soon as you add a selectman to that, or if you add, if I'm one member of a school committee and you add a member of the school committee, even if it's less than a quorum, if they've been designated as a group to do something, they're going to be subject to the open meeting law. Okay? Let's just take a different scenario then and say Selectman X and Selectman Y both happen to be really interested in planning board activities, and they both just go to the planning board meetings from time to time. Just because they're both there at the same time doesn't make them a subcommittee for purposes of the law, and the new law actually has kind of a separate exception for that, and it says just because people plan to be at a meeting or a training or something like that at the same time doesn't make them subject to the open meeting law as long as they don't deliberate. So not deliberating, and there's a definition for that too, of course. And deliberating means essentially taking in and responding to information. It could just mean taking in information, but taking it in their official capacities. So when two people show up at a meeting, even if they're both selectmen, they're not necessarily there in their official capacities unless they've been designated to do that. And it's that designation that's going to make them subject to the open meeting law. Okay? They're not going to turn into a subcommittee just because they turn up at the same place at the same time. All right? And the new law also says it's not a meeting, it's not a deliberation for people to attend a training like this one. It's not a meeting, even if a quorum of members show up at another board's meeting, if the other board has posted, as long as they're not there to deliberate. Okay? So what does that mean if you do, let's say the Board of Selectmen does want to go to the Finance Committee meeting, but it doesn't, it's not going there officially, but it wants to go hear what's being said. My recommendation is don't sit together, don't talk to each other. And if, don't talk to each other like, what do you think? What do you think? Don't do that. If you get up and you have something to say, you say it to the group. You say it to the people that are there. You don't say, John, my feeling is blah, blah, blah. And I think the Board of Selectmen would, don't you think? You don't say that. You just say, I'm a member of the Board of Selectmen, in my opinion, blah, blah, blah. And that gets the point across to your selectmen, but at the same time, you're not representing the Board of Selectmen and you're not deliberating. So that's something to be aware of. It also is good because it deals with this training session or conference issue, which before really was a problem. What if selectmen wanted to go to a private conference? Or what if the school committee wanted to go to a private conference and members of the public weren't invited generally? How did you do that without posting? Well, now, if it's really a conference, that's okay. They can go and do that. If they want to talk about what they learned at the conference, though, they have to come back and do it at a posted meeting. There's also an exception for site visits. It was in the old law as well. If you want to do a site visit, you don't have to post it. And the reason is you can't invite people onto private property without their permission. So you can't post your meeting at someone's private property and say, we're going to all arrive here at whatever time. You can go there, and if the individual is willing to let you all onto the property, that's one thing, but you can't force them to. Okay? In all of these situations, how do you avoid violating the law? How do you avoid deliberating? Schedule a meeting, a posted meeting, for an hour after your scheduled site visit or after your scheduled training conference or, your meeting with your with your insurers about lessons about municipal insurance generally, and your training on that issue, and come back here and talk about the issues in a posted meeting. Okay. Sometimes, particularly for site visits, someone will say it's really important for me to point out, gee, that fallen tree has been moved, and I think that's in a buffer zone. So it's fine to point it out and to say, please look at the distance between the fallen tree and the water. And then when you get back, you'd say, I asked you all to look at the distance between the fallen tree and the water, and the reason is I wanted to bring up how that relates to the buffer zone. But you do that part at a meeting. Okay, so what bodies are subject to the open meeting law? I think we get that. It's a public body. It's either created by bylaw or charter or a special act or a subcommittee of another the board or committee. And there's one kind of lingering issue about this. Sometimes people will say, oh, well, it's not really a subcommittee of my board because only 2 members of my 5-member board are on there. It doesn't matter how many members are on. If a committee creates another committee, that's subject to the open meeting law. So it doesn't matter how many of your members are actually on that second committee. All right? Okay.
So let me ask
Yes.
you. If we wanted to give a 9-member board, so it's great to have 9 members, which also fits on will be. If we want to have a couple people work with the director on preparing the draft budget or working on revising a job description, something like that. Typically, we've formed a 2 or 3 member small subcommittee to work with them on something like that in a working session. Is there a way to have a couple members work with her on a specific administrative issue without, which is going to be brought back to the full board later in an open meeting, without violating this?
The answer is,
call it a subcommittee?
The answer is not really. The only way to essentially do that is to say, look, we're going to have 2 point people for that. So if you have questions, call John or call Nancy. But it wouldn't be John and Nancy together working on the issue. As soon as you appoint them to work on it together, you've created a subcommittee. Yes?
You could ask them to put together a job description and bring it back to the board. You can deliberate it.
Yes.
Deliberate the job description at that level. But to send 2 members along to help write the job description, it's probably better if the professional staff wrote it and brought it back to the full committee for your deliberation.
Yes, and to John's point, let's say that your staff person did do that. Your staff person, and we'll talk a little bit more about this in a few minutes, but your staff person could email that to everyone and say, we're going to be talking about this document at next Tuesday's meeting. Do not respond to this email. This is being provided solely for your information. But, do not respond to all. So at that point, everyone can be thinking about the issues, but not emailing back and forth between each other. Or the staff person and 1 member of the committee can work as to their heart's content. Back and forth, back and forth, back and forth. It's when you have the 3 of them sitting down that it turns into a problem. Okay? This other thing that comes up is, well, we weren't going to vote, so it wasn't really a meeting. It was just a discussion or just a working group. Just because you don't vote, it doesn't mean it's not a meeting for purposes of the law. The big point is it a matter within the board's jurisdiction? If it is, if it's official business, it has to be done at a meeting, a posted meeting. And the other thing, too, in terms of where can meetings be held, sometimes there'll be a need to hold a meeting in another building or, and that's fine. The meeting needs to be in an accessible location, and it needs to have enough space for the people that want to be present. If you have an overflow situation, you may either need to reschedule your meeting or provide another location that's close by, so like down the hall, where someone can get to. You run into a risk that if you move it from one building to another, that people who have accessibility issues won't be able to get to that second building. And so you may be able to make an argument that the posting itself was still reliable and still in compliance with law. You put a note on the door and on the outside door, but if there was a person who had a hard time getting to that new location, it could be an issue. And my recommendation is that you do reschedule the meeting for another day if you cannot allow everybody who wants to be present to be present. It doesn't mean that anybody can say anything, but everybody should be able to hear what's being said by the board. Yes?
So say there was say to reschedule that meeting?
To either find a way to move it to a place where people could all hear, or reschedule, yes. And rescheduling, just in case, we should go back to posting for a minute. If you have a meeting that goes to 12 o'clock one night and you want to continue that meeting, you can continue it, but it has to be continued to a time when you can give the notice that's required by law, which is 48 weekday hours, so excluding Saturday, Sunday, and legal holidays. Okay? So let's say the board has a meeting tonight, and their meeting, because I speak for a really long time, goes to 11, and they think, oh, we better come back tomorrow. And that would be fine if they were already posted. If they're not, they can't come back tomorrow. They have to wait and figure out what time can they post with the town clerk's office, and then they can come back 48 hours from that, from the time they post. So, especially in terms of land use hearings, this is really important, because if you don't continue your meeting the right way, you wind up having to re-notify everyone. That's one of the open meeting law myths. Let's talk about that. Does the open meeting law posting count for the purposes of complying with any other statutes? No. And same way the other way. Just because you notified voters under the Zoning Act doesn't mean you've complied with the open meeting law. You have to do all of the posting that's required by all of the applicable statutes. So just because, let's say, under the zoning law, you could continue a meeting, to the next day, you can't comply with the open meeting law by doing that. So what could you do? If you think this is going to be the type of topic that's going to take a few nights, I'm thinking finance committee and articles at the last minute, you might post for 3 nights in a row thinking, we will use these 3 nights. If it turns out you don't actually need the 3rd night, you'll cancel your meeting. But you couldn't post for Monday, Tuesday, Wednesday, Thursday, Friday of every week, because clearly you're not intending to meet for those nights. Okay? So you can try and post ahead of time. Keeping in mind this posting requirement, one of the other important things about it, and I should have mentioned that when we were back at the notice, is that if you have something on the agenda, let's say you don't have something on the agenda because you don't know it and you post, but something comes up in between then, so the next morning or later in the day, you're supposed to update your agenda, your meeting notice. Now, under the old law, no agenda requirement, no updating, no nothing. You posted, you're set. Now you have to update. So if something comes to your attention that you didn't know about when you posted, if you're the chairman, but it comes to your attention, like let's say John brings something up to the Board of Selectmen, they didn't know it at the time, but it comes up later, but before the meeting, you update your meeting notice, okay? And that's fine. If the chairman has no reason to know, then there's no issue. You're not going to update anything. But if the chairman has reason to know, it should be updated. So, if John is in the process of giving notice to the chair, you would also give notice to the clerk. We're going to add this item as well. Yes?
Does that update fall under the same 48-hour?
No. So if it happens within the 48 hours, you update, and that's fine. If you had reason to know ahead of time, and you update after the 48 hours, then someone could complain and say, you should have had reason to know and you didn't update.
Well, like if you had a meeting on Monday and something came up at that meeting and you have to, and you've already posted for Tuesday.
Yep. You just add it.
Something comes up at Monday's meeting
Yep.
that is not on your agenda.
Yep.
You can then discuss it on Tuesday without having to follow the 48-hour
Yes.
posting.
If it came up on Monday and it wasn't on the agenda at all, you could talk about it on Monday. Because the only thing you're not, quote-unquote, allowed to talk about is something that the chairman did reasonably anticipate but didn't include. Okay? And if this sounds like a crazy quilt that we're putting together of rules here, it feels like a crazy quilt. I think, the important thing for people to know is this is a learning period right now. It's a learning period because the AG has just started issuing these decisions. And it shouldn't be, and I've had this conversation with them, that this notice information right now, it shouldn't be used as a gotcha mechanism. You can't talk about that, it wasn't on the agenda. Everyone is trying to do the best they can to learn the rules and follow them. And so if something's not on the agenda because it wasn't reasonably anticipated, it can be discussed right then and there. But let's say it comes up, and this is actually a real case. In Nantucket, I believe, there was an issue that came up at a meeting, I think on a Monday night, for a meeting that was already posted for Wednesday, and by the time it was already posted, and so they didn't know when they posted what the issue was, and when they went to post it, it had already been, 48 hours had passed, and the AG said, no, it's okay, because the agenda already, the agenda had already been posted, you just needed to update, and it was updated, and that's the best that you can do. So if something comes up on a Monday and you're already posted for Tuesday, you just add it to your Tuesday agenda. and that's fine. And, it would be obvious it came up on Monday because it would be in the minutes. So, you could trace it back fairly easily. It wouldn't preclude you, though, from having the conversation on Monday if you so chose. Okay? Although, as I said, the AG is encouraging you to do it at a meeting where it appears on the agenda. And the thinking behind that is this is an open meeting law. The purpose of the open meeting law is to get rid of or to avoid secrecy and encourage transparency. And so by having more information on the agenda, it gives more information to the public, and they can decide whether they want to be present or not, if they have an invested interest in what's going to be happening. Okay, so what constitutes a deliberation? We talked about you can go to the site visit as long as you don't deliberate, and I mentioned that the AG and the DAs before them have taken a position that just taking in information is a deliberation. So there's a case, the Northampton case, Attorney General v. Northampton, where there were some interviews performed, and the interviews were done with one person doing the questioning, and none of the other members asked any questions. Okay, so the members didn't talk to each other at all, and the court said that's a deliberation. Why? Because the information that was being taken in was going to be used as part of the decision that they made on the appointment. Now, this has pretty far-reaching consequences, and the most direct of which is email. Okay, if you receive a substantive email that includes a matter that's within the board's jurisdiction and goes to a quorum of the board, then that's going to be viewed as a deliberation. And the new law explicitly includes email. Okay, the old law, almost all the DAs agreed that email could lead to a violation, but the law didn't say so, and there was one DA that was kind of on the fence. Now that law specifically says so. So, what does that mean about what you can use email for? And this is really important. Email should be used sparingly, and it may be used only for administrative purposes. Okay? And my recommendation is that you avoid sending emails between even less than a quorum because of a few reasons. One, it's easy to have that forwarded to, let's say, with a 5-member board, a third member, and now you've hit a quorum, violation of the open meeting law. Or easy to hit, especially if someone does send out an administrative email, your administrative liaison in town hall, or the chairman, let's say, sending out the agenda. If someone hits reply to all and says something like, great idea, this is really important to me. That great idea, this is really important to me, causes a violation of the open meeting law. Because that's the sharing of beliefs, opinions, and ideas. And that's prohibited by the law. And I see you shaking your heads, and I know it is a stiff, difficult rule to comply with. But if you send out something which shares your ideas, beliefs, or opinions to a quorum of members, even if no one replies, just taking in that information constitutes a violation of the law. So, you may ask your chairperson, or you may email your chairperson and say, please include 12 Main Street on the agenda for Monday. 12 Main Street, dash variance with a question mark on the agenda for Monday. But you cannot say, because the place is a dump and I'm really concerned about how it looks. Because if you do that, you violated the open meeting law. If everyone gets that. If you send it to the chair, but you copy all your board members, now there's a violation of the open meeting law. If you have a 3-member board, just sending it to the chair with that is a violation, because that's 2 members, that's a quorum. And if you have a larger board and you send it to the chair and you copy 1 or 2 people who you agree, you kind of have a like-minded position with, but then the chair forwards that to everyone, for example, or sends it to one more person, and now you have a quorum of a board, that's a violation of the law. Okay? So email is dangerous. It is specifically included in the definition of a deliberation and of a meeting. So you want to be very, in the definition of deliberation, an oral or written communication through any medium, including electronic mail. All right? So now it's no longer just a question. It is subject to the open meeting law. Okay? And so this is where we take, and I'm sure John's heard me say this before, but sometimes we give out advice ahead of time and we're like, this is the conservative approach, be careful, you don't want to this, you don't want to that. That's what I'm telling you. Be careful. Be conservative. Don't expose yourself to a potential challenge. Particularly in land use litigation, we now see counts for violations of the open meeting law, violations of the public records law, violations of the conflict of interest law. Judges get distracted from the substance of the issue when they're hearing that towns violated the public records law, open meeting law, conflict of interest law. Even if you didn't, even if we're successful on that, they're thinking, what's this board about? They can't get any of this right. And this is the public's right to know, and they've screwed that up. I think it undermines their thought process about what your position was on your substantive discussion or your substantive decision. So you want to be careful, and particularly with land use issues or any other issues where rights are being adjudicated, there's due process concerns. You're supposed to do all of your thinking about a hearing at the hearing. The evidence is supposed to be at the hearing. So even though you might each individually bring your own position or your own ideas, you bring them to the hearing and you talk about them there versus doing it behind closed doors, even if it's less than a quorum. Because there's always that risk then that it's going to get to more than a quorum, and email is a facilitator of that. That reply to all button, never use it. If you have an administrative liaison, right back to that person. Okay. Now, administrative people or chairpersons, you might think, well, how are we supposed to get this stuff out? Selectmen get a packet. Can't we do the selectmen's packet? Yes, you can. And you can forward information from other people. You can forward my ideas and opinions. You can forward John's ideas and opinions. You can forward another kind of consultant's ideas and opinions. That's fine. You can forward a resident's ideas and opinions, just not your own. Your own you save up and you talk about it at a posted meeting. Yes, question in the back.
If I send, I'm the health agent, if I send something out to the board, either for permission to buy something or just something I've written and want their opinion on it, am I violating the open meeting law to do that?
No. You're not a member of the board. You're the agent.
Are they violating if they respond back?
Not if they respond to you only. But if they respond to each other, then it could be a violation. And if you're looking for an official action, then you'd want that to happen at a meeting. If you're trying to get feedback or, but again, and I think this is kind of a policy decision about how much of that you'd want to have happen by email. Their discussion should truly be at an open meeting. So you might say, attached, please find my draft decision for this matter, and then they might write back, I didn't like paragraph 2 or I didn't like paragraph 1, but then you would take all that to the meeting and you would say, I got back some feedback that so-and-so didn't like 1 and so-and-so didn't like 2, so I've revised that and here it is for you to look at and talk about. Okay, you wouldn't send a new draft incorporating everyone's changes because that would essentially have been a meeting that didn't happen at a posted meeting.
They have the right to respond back to me individually.
They can, but you want to avoid the situation where you're basically polling or using the information that they give you to give a new draft, because it's going to create a situation where really there was feedback from a quorum of members. So it's not an actual straight line violation where you can point to it and say, but you could see that someone could raise a due process question and or an open meeting law complaint. But certainly to send it out and say, I'd like to discuss this at the meeting, or if you're working with one person, you can go back and forth as much as you'd like. Okay. Were there questions over here too? No. Okay. All right, so the other thing about the open meeting law and the email issue is the public records component of that. And I just want to remind you that any record made or received by a governmental entity, including individuals, is a public record in its entirety, subject to mandatory disclosure upon request, including, and unless it falls into an exemption, and subject to records retention requirements. So when you make an email and you send it from your home computer, it's a town record. And it needs to come into town hall and be stored in the town.
If you talk about...
If it's public business. Yeah, if it's private business and you just happen to be friends and you're, interacting, even if you're on the same board, if it's just about your kids or, someone needs a ride, none of that, that's not public. But if it's about town business and it's on your home computer, it's a town record, regardless of it being on your home computer. So you need to have some sort of plan in place. Either if you have a liaison in the office, and this is where people like the health agent look at me and roll their eyes like, are you kidding me? You need to copy them on your email, or you need to print out your emails and bring them into every meeting that you have. Okay? So if you're the liaison person You know, you were saying before that you're supposed to be working with one member of your committee to come up with a draft job description, and you go back and forth with your liaison, with your administrative person. Well, you don't need to print out all of those because the administrative person has copies of everything. They can print it out. But if you're emailing your chairperson about keeping putting an agenda item on, and you go back and forth a few times, well, I'd really like this item on. I don't think the agenda's big enough for it. I'll think about it for next week. Those are public records. And if you violate the open meeting law, then those public records are going to become part of the cure. They're going to be added to the public record so that everybody knows what was exchanged in those emails. If they should have happened at an open meeting and you have a record of it, it makes sense that you would make the record part of the public record. Okay? So this is also where I give out, and I'm just going a little bit into public records for one more second. I like you to think of this standard when you're writing an email relating to town business, and that is, are you comfortable reading that on the front page of the newspaper? If you are, press send. If you're not, do not press send. Okay? Email can be forwarded to anyone at any time without permission. And it often does get forwarded. Not a malicious nature. It just does. And sometimes something that you said in jest doesn't look so funny when you read it in the newspaper. The other thing is, if you are friends with someone and you tend to include both work and non-work related or non-town business related information in the same email, I suggest you think carefully about that practice. If a public records request is made for the record, then you have to take the initiative to redact the part that isn't public. If you can, if it's private, it could be that since it relates to town business, it's in a town email, and it's not private the way that, the term is defined for the law, that it could wind up having to be disclosed. So think about what you put in your emails, and particularly if it's a friend that you're emailing with, you want to try and separate that out. Okay? Any public records email questions? Yes?
How long does
The content of the record determines how long it has to be maintained for. What that means is that, and you'll actually see in the packet of information I gave you, there's a memorandum that we sent to municipal clients after the Boston mayor's first assistant issue. And at that time, I don't know if you recall that the Globe printed that every email had to be saved for 2 years. That is just patently untrue. It has to be saved for the period of time that the content dictates. So if it is, let's say it winds up being the minutes of a meeting, let's say it really was an internet meeting or an email meeting, then those minutes would probably be permanent records, need to be kept forever. Okay, versus if it was administrative and it has no useful value, it might be after use. But it depends on what's in the record. And it's the same for any record. It's what the record is that dictates how long it has to be kept and not what it's packaged as. Okay? And just so that you know, there is a municipal records disposal schedule online at the Secretary of State's website. And included in here is a public records outline that I did for the Mass Municipal Association earlier this year. And it goes through public records retention and email in there, so you can look in there, and there's a bunch of information, as well as specific retention issues related to email. Related to open meeting law. So those are in there. And we talked a little bit about what this jurisdiction issue means, if it's within the board's jurisdiction. And the short answer is, if the board talks about it, it's in the board's jurisdiction, even if they don't have the right to vote on it, or even if their vote's just advisory. Okay? Okay. Let's see what else. Just skip ahead a little bit. All right. What information does your meeting notice have to have? I didn't mention date, time, and place of the meeting. Okay, and then those topics. Just want to point out that the AG's outline of this is one tiny little topic, and I talked about that for about 20 minutes. So just know these things are useful, but they don't really tell the whole story. Okay, when can a body meet in executive session? The first and most important answer is only after it's met in open session. Okay? Anytime you want to go into executive session, you have to meet in open session first. All right? So if you are in an executive session and you're going to continue that executive session to another night, that's fine. You need to repost, and you need to open an open session, okay, and take your vote again to go back into executive session. You also need to state the reason that you're going to go in, which is the exemption that's applicable, and as much information as you can give that doesn't destroy the purpose for going into executive session. That's a change from before. It used to be suggested by the DAs, but it wasn't required by law. Now it's required by law. So I gave a few examples of that. If you're talking about a person, non-union personnel, and you're going to be negotiating with them, you have to put that on the notice. With a case, you might make a different choice. If you're going to be interviewing candidates for appointment and you're meeting in executive session, you don't need to say who they are. That's the whole reason you're going into executive session, is to preserve their privacy. But in each case, you're going to have to think, would it destroy the purpose of this session if I had to say the exact reason I was going in, or do I just need to say the purpose for which I'm entering executive session? And then you need to say whether the entity is going to reconvene at the end of the vote. At the end of the meeting. And the reason is the people need to know whether they should stick around. If you're just going to go home afterwards and you're not going to come back out into open session, then there's no point for people to wait. But if you are going to come into open session, then people might choose to wait. So you have to say whether you're going to come back out into open session. In addition, you have to take a roll call vote to go into executive session. It has to be recorded. Is it good enough to say unanimous if everyone votes yes? And the answer is no. You're supposed to write down everyone's vote, roll call vote. The other thing is, in minutes, and we can talk about this as well in a minute, but you want to have the members present and absent listed. The law says present or absent. It actually means and absent, and the AG's new guide says that. So stick with that. And the reason is, you know who's not there today, but 10 years from now, will you remember, or will someone else know? And so then, even in your open session minutes, if you say unanimous, and you only have, it doesn't say who's absent, you don't know whether, did someone come in, did they not, and you don't know who those other people were who didn't vote. Okay, so you want to put members present and absent. The reasons for executive session really haven't changed, except that, and you got to love lawyers and you got to love legislators, they conflated two of the exemptions into one, and then they expanded one exemption into two, which is really great, right? The first one is that they put all the personal discussions into exemption 1. So now it says reputation, character, physical condition, or mental health rather than professional competence, or to discuss the discipline or dismissal of complaints or charges brought against a public officer, employee, staff member, or individual. The person who's going to be discussed has to get notice. They have the right to be present. They have the right to speak on their own behalf. They have the right to be represented by counsel or a representative. And now they also have the right to tape their meeting. Okay? Interestingly enough, their representative does not have a legal right to speak. They have a legal right to be present, but not a legal right to speak. The individual has a right to speak. Why is that important? Well, the chairman of the meeting, of the board, has the right to control who speaks and when. So this is really meant to kind of override the chair's ability to say, and not you. So the individual who's being discussed has an opportunity to speak. When that decision is made is up to the chairman. Okay? But if is not a choice anymore. If the individual wants to speak, then the individual gets to. Okay. Again, it depends whether you're going to be able to say the individual's name in those situations. It depends. You'll have to make a decision on a case-by-case basis. Reputation, character, physical condition, or mental health, you're certainly not going to specify which of those things that you're going in to discuss, because then, if it's mental health, well, we've just given away the store, and we could have also violated HIPAA, so we need to be careful about that. Consult with the town manager if you have questions, because better to ask first and be, as I said, be conservative and careful than to ask later and have created an error which, results in liability to the town. Right, John?
You can't ask for forgiveness.
Exactly. Then what they did is they took the litigation and negotiation sections and they split them. So the new number 2 is to conduct strategy sessions in preparation for negotiation with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. And the second one is to discuss strategy with respect to litigation or to collective bargaining or litigation if an open meeting would be detrimental to the town's position. Okay? And the chair has to declare that. So before you just say, I'm going to go in under exemption 3, which would make the point that it would be detrimental to the town's position to have the discussion in open session. Now the chair says so. I'm not going to go through the rest of them. They're in my outline, which you don't have, but you'll get, and they're in the AG's outline. So you really, and they're in the law. And also, they're in, I gave you a printout where we kind of summarize what the rules are, so you can use that. So question about remote participation. Some DAs were allowing remote participation. The law, as amended, says that remote participation may be authorized by the Attorney General. The Attorney General has issued some regulations. Has anyone seen them? They're draft regulations. Anyone seen them? No. Interestingly enough, you can participate remotely if you're sick, and state members of public bodies can participate if they're geographically inconvenient to their meeting. But that same courtesy has not been extended to local officials in the draft regulations. So if you're sick, you can participate remotely, but not if you're out of town. So I have a feeling that the Attorney General heard a lot of feedback on that during its hearings and its public comment period, and I'm hopeful that the regulations, when promulgated, will include the same permission for municipal members of public bodies. And the other side of that is that the minutes of meetings where people are participating remotely are going to have to include a few more items, such as where everyone is who's participating. There needs to be a quorum present physically in the location where the discussion is going to be, and the person who's going to serve as chairman also has to be physically present where the discussion is going to be. And the reason for the individual's remote participation has to be recorded in the minutes as well. It's up to the chair to decide if he or she has more than one request for remote participation, what's going to be allowed, because as I said, you need the quorum present, and the Board of Selectmen in the town will have to decide whether to allow remote participation generally. Yes?
So the remote participant has to be the fourth person, cannot be the third person, because you wouldn't have a majority.
Yes, you need a quorum present, physically present.
So it needs to be the fourth or fifth person in a 3-member board.
In a 3-member board, you'd have to have 2. Yeah. So at this time, it's still not, the regulations aren't final, so remote participation is not allowed. But it's coming, and when it does, we will be sure to notify you. Okay, what public participation has to be allowed at meetings? Well, none. Well, don't you like that answer? That was a one-word answer. No one cheered. It's up to the chairman to decide who participates and when. And that includes members of the person's own board as well as members of the public. The open meeting law does not guarantee the right to the public to participate, period. Some boards, as a courtesy, allow it. Some towns have a bylaw, but the open meeting law doesn't require that. Okay? In addition, if someone acts out when the chair says no, someone says, I want to talk, and the chair says, no, you can't talk, and the person says, well, I want to, and the chair says, you have one warning, and then I'm going to ask you to leave, and the person talks out again, the chairman can actually, by law, have the person removed and forcibly kept out of the meeting. Okay? If the chairman wants to exercise that authority, I suggest that they think about it ahead of time so they know the procedure they're going to use and have the police chief's number on file so that you don't wind up getting in a skirmish, because that's not good for a meeting. Right? Has anyone ever been in a meeting where that happens? Maybe town meeting. Has anyone ever seen that happen at town meeting? It's not pretty. It's difficult. So be prepared. Okay. What records of a meeting have to be kept? Well, you have to have minutes of every meeting. Time, date, place, people present or absent. The new requirement in the law is that there be a summary of the discussions had, as well as a record of all quote-unquote actions taken, which would mean votes. Okay? What does a summary mean? Does anyone want to fathom a guess at the fact that we have no regulations about this and the law doesn't say it? You tell me. I don't know what a summary means. It means something along the lines of when a person reads the minutes, they have an idea about what was discussed. It does not mean a transcript of the discussion. And in fact, I very strongly urge you against having a transcript style of minutes, because, and I don't know if anyone's going to nod their head at this, but you get into the situation where people say, well, I said blah, 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 and you wrote down that I said blah, 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 blah. And I spoke for 5 minutes, and she spoke for 3 minutes, and I have 1 sentence, and she has 3-minute sentences, and I don't think that's right. And you get in this back and forth about whether the minutes accurately reflect exactly what was said, and that's not the point of minutes. The point of minutes is supposed to be a record of the meeting to allow some permanent history of what happened there, not a play-by-play. And in fact, just from personal experience, I will share with you that a board in an unnamed town wrote a lot of things in their minutes that probably no one wanted to see again, including some swears and definitely some personal attacks. And that meeting was the subject of an appeal on the substantive matter, and the minutes were submitted to the judge, and the judge's decision said, obviously, this is a dysfunctional board. And that is not where you want the judge to be coming from. You just don't want that part of the discussion to be the judge's main focus. So people may fight at a meeting, and you might put down something like, there was strong disagreement among the members about how to proceed. That's a perfectly good summary. Okay?
It doesn't have to be verbatim.
Not verbatim. I'm suggesting no to that. Now, land use boards might say, well, sometimes it's really important that we have a lot of information in the minutes, and that's true, but it still doesn't need to be a verbatim recitation of what everyone said. You can certainly have a lot of facts in the minutes, and you could even have the board discuss the following, or the board members stated the following, and you can have a list of 17 important facts, but it doesn't need to say Sue said this, John said this, Tom said this, Lauren said that. Okay? Does everybody take verbatim style minutes? No. Good. That's what I like to hear. Okay. The other thing that the minutes have to have now is a listing of all the documents, quote unquote, used by the board at that session. Used by means used by the board. It doesn't mean on June 13th I got a memo from Lauren and she was really in favor of non-verbatim minutes. That is not use of a document dated June 13th. That is a reference to a document dated June 13th. But if instead I say, I got this memo from town council, and I feel really strongly that she's wrong, and right here she says, I'm reading this into the record because I want everyone to know, blah, blah, blah. Now the board has used that document at a meeting. So it's more than a reference. It's a substantive reference. It's substantive use. It's using it. Yes?
So you just include it with the minutes?
Well, you just have to have a list of it, okay? No, just a list. Now, the question is what happens to that regular record, and the AG's office and the Supervisor of Public Records appear to be saying you keep it with the minutes for 6 months, and then it goes back to wherever it came from. Sometimes that works and sometimes it doesn't. I think as long as you have a reference to it and you know where to find it, you've complied with the law. If you can't find it, that's going to be a problem, okay? If you have a copy, I mean, that's great. If it's a 2-page memo, no big deal. Make a copy, put it with it, you're all set. This really turns into an issue for, let's say, the Planning Board or the Conservation Commission or the Board of Health, where they get huge sets of blueprints and plans, and you can't have 2 copies of it. It doesn't work. And you're not going to keep your blueprints over here with your one file of minutes when your entire working file is over there. And I think that's okay, as long as you know where to get it. Okay? You have to have the list with it, and you have to maintain it in a place where it's accessible to you, so if someone asks for it, you can go get it. You have to know where it is. Okay? All right. So that is that. Now, public record status of open meeting minutes. If you have minutes of an open meeting, generally they're going to be considered public in their entirety. Okay? There may be a case, let's just say that, I don't know, the Board of Registrars was considering something relating to a permanently disqualified voter, and they happened to name the name of the voter, and it happened to get recorded in the minutes, even though it really shouldn't have. I still think you can assert the exemption to withhold that name, because to disclose it would be violating a law, 214(1)B, which says that people are entitled to protection from unreasonable invasions of privacy. So we wouldn't want to perpetuate giving out something that would invade someone's privacy if it wound up in an open meeting document by accident, okay? Or, it was a fine discussion, but doesn't need to be in the minutes. So you could still redact. But in general, your open meeting minutes are public records from the moment of their creation. And this is important for someone who acts as a clerk for a meeting. Even if they're your personal notes, if you are the clerk of the board, they're public as soon as you write them down. So right after the meeting, someone can come up and say, hey, can I have a copy of your notes? And you could say, oh, sure, I'll be happy to get those to you within the 10 days, no problem. But they are public just like how they look right then, even though the full board hasn't voted on them. My recommendation is to write draft at the top of every page. So it's clear. These are the draft minutes. They're not the board-approved minutes. In other circumstances, let's say you get no request for a copy of the draft minutes, the board votes on the minutes at its next meeting, you take your personal notes, you throw them up and you toss them, that is fine. One of the only times you can destroy a record without the permission of the supervisor. The other thing that's fine is if you're making a tape solely for the purpose of creating the minutes, you can reuse the tape as soon as the minutes are approved. There is a new line in the disposal schedule that says if the cable committee is making a tape for purposes of broadcast, that has to be kept for 6 months. But that's not the same as you making a copy of a tape for your own personal ability to write up the minutes. Okay?
Does that become, if somebody asks for a copy of this tape, they would have to disclose?
Yes, it would be a public record from the moment of its creation because it is essentially your draft minutes. Okay? But you could destroy it once the actual minutes have been approved. Unless you've had a public records request for it, and then you're going to keep it. Okay? So the important thing is, if you're the clerk of the board, whether you're a staff person or a board member, your minutes are public as of the moment of their creation. All right? Executive session minutes do not become public as a moment of their creation because that would destroy the whole purpose for the executive session. The same rules apply, except that the minutes of open session, when you want to go into executive session, have to include, as we said, the reason, the as much information as you can give without disclosing, without ruining the purpose for going into executive session, a roll call vote to go in, whether you're going to come back out, and all that information is recorded in the open session minutes. When you get into executive session, you're going to do the same thing. Who's present, who's absent. You're going to say the reason that you were in there, and then you're also going to take every vote you take in executive session is a roll call vote. Okay? All right. The minutes will stay private as long as releasing them would destroy the purpose for holding the session. When the purpose for holding the session is no longer applicable, then you can release the minutes. If you get a public records request for the minutes, there's a new provision in the law that says that the chairman should go through from time to time and review that and basically make a recommendation, it doesn't say this, to the committee about whether to release these minutes, and they can be released on a rolling basis. The committee can go into executive session to discuss whether to release minutes from executive session, and you can do it under the same exemption you were in originally. So if you're in under exemption 3 to strategy with respect to collective bargaining, you go back in under exemption 3 to look at that. The new position of the supervisor and the attorney general is you can vote to release those minutes and still redact information from them that you think needs to be withheld under the public records law. And this is a brand new, well, from my perspective, it's relatively new position formally for the supervisor to have taken, which I think is very useful for towns because it means that it may be that you vote to disclose your executive session minutes, but that there's still information in there that gets protected under the law, and I think that's quite useful. It's useful to protect people's privacy. It's useful to protect the town's position with respect to litigation, with respect to collective bargaining. So, if you get a public records request for that type of information, you may have several responses in your response to the public records request. You may say the executive session purpose has not been met, but if the AG determines it has, you're going to assert this exemption to withhold this portion from disclosure under the law. Okay? You have 10 days from the date the request is made if if the chairman has been going through, or until the board's next meeting, whichever is less. Okay, so if the board is going to be meeting within 10 days, at the board's next meeting, the board considers whether to give those minutes out. Okay? Complaints, and we're wrapping up the open meeting law and moving on to the conflict of interest law quickly. Complaints are different under the new open meeting law. Complaints are filed originally with the public body. The public body has 14 business days, not 14 days, 14 business days to respond, and that response includes a requirement that the board meet and quote-unquote consider the complaint. It means the board has to have a meeting at which it acknowledges that it's received this complaint essentially, and if there's already been a consultation with town council, then to say town council recommends we proceed like this, or we want to get town council's get authorization to have town council prepare a response, or this is how we choose to respond. But the board has to be involved in determining how to make that response, and then the response is actually given to the individual, although in many cases I have recommended that the response actually be directed to the attorney general rather than to the individual, have the individual be copied. These things are often heated, and sometimes it's nice to have a layer of neutrality in between, so oftentimes when I've prepared responses, they've gone to the AG, CC to the individual. Then the individual has 30 days from then to decide whether they believe that the board's response is okay enough for them, if it satisfies them, and if it doesn't satisfy them, then they get to file a complaint with the Attorney General. The Attorney General has rejected complaints made directly to her. The AG then has 90 days from the date they receive the person's complaint, the second complaint, to resolve it. It's not a 90 days set in law, but that's their goal. They are a little understaffed right now, so they have acknowledged that some of their responses have taken a longer time. The AG has a significant amount of authority under the law, including after a hearing before an administrative law judge to undo the decision that the board has taken, which is what a judge can do under the law as well, to impose a fine of up to $1,000 for intentional violations, to order a person back to work if they've been quote-unquote wrongfully terminated or wrongfully suspended. They have a lot of authority. We talked a little bit about how do you cure a violation, and the way you cure a violation is when you realize that a violation has occurred, and many times, and I think it's very important that the public acknowledges or is aware, these things happen accidentally. You get to a quorum by accident. You through email, it's an accident. You don't put something on the agenda. It's not intentional that the chair would reasonably have anticipated. It's an accident. These things happen. The best thing to do is to be upfront and open, take it before the next meeting of the board or schedule a special meeting, bring the whole matter back in front, give everyone an opportunity to deliberate on the board. It's not enough to just say, I'd like to reconfirm our meeting that we had the other day and everyone all in favor, aye. That's not a deliberation. That's just a perfunctory ratification, and that's not going to satisfy the AG. You want something more. Have a discussion on the record. Why is this important? Why was that email discussion? Why did it happen? And what is it? What are the issues that were raised? Why do people care about this? Have a full and fair discussion on the record, and then vote. And as the chairman, if you think the vote is moving too quickly, then the chairman says, I want to slow this down and really give us a chance to talk about it. You don't have to accept, a vote until you're ready. And so once you do that, so that's one step. Vote it again on the record. The second step is to put the minutes from that executive session that wasn't, and if an executive session was held improperly, you put those minutes as part of your open session meeting minutes. If there was an email chain, you put the email chain as part of your open session meeting minutes from that next meeting, and essentially you bring what happened in private out into the public, and that will cure the violation. The AG has recognized that case law still applies, and some of those remedies are things that they would order. If you didn't take minutes of a meeting and you needed to, and it was a violation not to, recreate the minutes of the meeting. If the minutes weren't adequate and that was the violation, flesh the minutes out. And you can do that on your own. You don't need to wait for a complaint. If you see that something went wrong, or someone says, hey, I'm concerned about this, or I've heard that someone might file a complaint, bring it up on your own. The DAs were very, very, very happy and eager to see towns and boards take responsibility for their own violations. And I have no reason to believe that the AG will be any different. I do think that it matters to the AG, it matters to the public to see you take responsibility for these things. And, you're volunteers, most of you. And if things go wrong, they go wrong. It does not mean that that's a time to take a defensive position and say, hey, we're not doing anything different. It's time to say, all right, if we messed up, if it was an accident, or if we didn't realize this was the law, we're gonna make it right, and this is how we're gonna do it. So take the initiative and do it yourself. And by the time that a complaint is filed, you've already taken the initiative. So when we write the letter to the complainant, we say, oh, this was put on an agenda at the next meeting. It was fully and fairly deliberated. The minutes reflect that. Plus, there is the minutes from that earlier meeting appended to this. And as you can see, it was discussed for 45 minutes. Everyone had something to say. That's the way to do it from my perspective. In addition, you should know that the AG can initiate a complaint on on her own, can bring forward a complaint on her own. And any 3 registered voters of the town or the Attorney General can also go to Superior Court directly. As I mentioned, these counts are more often seen now in land use decisions than they ever have been previously. What else was I going to say? Oh, emergencies. sometimes there are emergencies. The hurricane is a good example. We might think we're prepared for these types of emergencies. It could be a snowstorm on an election day. That's my go-to example. We hear about it on the news, but we don't necessarily post a meeting of the Board of Selectmen on the same day that there's going to be an election. Or, we all of a sudden hear, tomorrow it's going to be 3 inches, and the next thing you know, there's 12 inches of snow. The Board of Selectmen couldn't have reasonably anticipated that. If they needed to cancel an election or to change the polling hours or something, they can have that discussion. What do they need to do? Comply with the law to the extent possible. As soon as they think they're going to need to meet for an emergency, post. If they can come to town hall, meet at town hall. If they can't come to town hall, they can call on the phone. But as soon as they can, post a meeting to redo what they did in offline, online at a posted meeting. Do only what's necessary at that emergency meeting, okay? And an emergency isn't, gee, we didn't know that was a filing deadline, so we didn't get our act together. Or, we didn't know that if we didn't meet tomorrow it was a constructive grant. We just realized today that's not an emergency. An emergency is a threat to public health and safety that couldn't have been anticipated. So Board of Health context, for example, a house that needs to be condemned. Water and Sewer Board, it would be, an overflowing sewer. Board of Selectmen, public safety to the roads or to, an election type thing, something like that. Open meeting law questions. Yes?
As far as posting, what constitutes posting? Was there a change in that? As far as where it has to be posted?
Okay, the posting now has to be done in a location that's available to the public 24 hours. That was what the law said originally, and the AG came out with some regulations some weeks, months after the law took effect, saying it would also be good enough to post a notice that said all of our postings are available 24 hours a day on our website. So they should be on the bulletin board, available 24 hours, unless the town selected an alternate method of posting, which would include a posting saying it's available 24 hours on the internet.
I would just like to say that if boards and committees are not posting their agendas on the website, they should do so, because that would constitute 24 hours a day, 7 days a week, or any information that they want out to the public. We should make sure it's posted on the website through your staff.
Yeah. And the other option is, if let's say your bulletin board isn't available to the public 24 hours a day, another option is to put the list of meetings, a hard copy list, in a place that is, like the police station. Okay? Or, sometimes towns have those kiosks outside where you can lift it up and with a key and put stuff in there. Okay?
What about the timing of releasing the minutes for a meeting?
There's nothing in the law about it. It should happen in a reasonable time frame. The DAs used to say 2 to 4 weeks. I know a lot of towns, they get behind.
It was a 60-day.
I don't think so. Hold on. It could be, and I just...
It was in the charter.
Maybe in the charter.
I don't think it says so in here. I think it says a reasonable time. I'll double check that. But
Maybe a town requires.
I think, it's important to know that as time goes by, you have less and less memory about what happens at a meeting, and that's why, I recommend you just put it on as item number 1 in your agenda. Approve minutes of your last meeting. Just do it every time. And as you said, if you're not creating these transcript-style minutes, it shouldn't be that difficult. I know I'm saying that because I don't have to do it, but it doesn't have to be a word for word. It has to be a summary. So if you get in a good habit of it, if you're the clerk, then you should just be able to keep it current. And if you're the clerk and you're behind, I suggest that what you do is you say to yourself, I'm going to do this current week's minutes and one more set each week till you get it done. Make it reasonable for you to be able to handle it.
If there are certain times of year where the board doesn't meet on a regular basis, so holidays.
Yep.
The next regular meeting.
Could be a month later.
It could be 60 days later.
Yep, whenever it is. Whenever the next meeting is, for the open meeting law, at least as I recall, that would be fine.
The charter says 60 days.
The charter.
Charter.
Yeah.
I think it's 60 days.
It is. I just looked it up.
Thank you.
The problem is if you happen to be an extra week out of the 60 days, if you happen to not meet.
The charter is the charter, and the open meeting law is the open meeting law. So it may be in conflict with the charter, but it wouldn't conflict with the open meeting law. So I mentioned the AG's website, and I'm going to encourage you all to go there and check that out, particularly the decisions. But they have a great guide, and I have a great PowerPoint presentation, and you'll get that as well. All right, we have less time for the conflict of interest law, but that's okay with me. And the reason is that people's conflicts belong to themselves, okay? When someone violates the conflict of interest law, as hard and stressful as it is as a member of a board for you to sit there and watch another board member violate the law, it really is a personal issue. Now, what can a board do? And this is really what I think I hear about the most. What can a board do if a member is violating the law? The chairman can put the meeting off, okay? And the chairman or another individual on the board could talk to the individual with the potential conflict and say, look, we're really worried about this, because there is a law that says that a court can undo the action that you take, okay, if it's a result of a conflict. And that's not, we're not looking at this anymore. Oh, guess what? You do have my open meeting law outline. It just says conflict of interest law on the outside. Sorry, guys. So you have it. You already have it. You have it. It's fabulous. Okay. This is, I really, it's the wrong one because you have it. All right. So we're going to go through this quickly. I also really try to avoid, for purposes of conflict of interest law, to answer anyone's specific questions. The conflict of interest law is a spectacularly fact-specific matter, okay? Just because something might look like a conflict doesn't mean it is, and just because something doesn't look like a conflict doesn't mean it's not. It matters each time that you look at the law and the facts. So I'll go through the general statements, but every time you need to keep in mind that it's personal. Each of these issues is personal and fact-specific, okay? So the conflict of interest law has been around for a long time, and it regulates all public officials and employees of the Commonwealth. It was created with 4 divisions: legal, statements of financial interest, public education, and enforcement. What's important about that? You only want to deal with legal. You do not want to deal with enforcement. Never call the State Ethics Commission to say, yesterday I participated in a matter and I'm worried I might have a conflict. They're going to say, hold please, and transfer you to the enforcement division. Okay? Forward-looking is what you want if you're calling the Ethics Commission. They have an attorney of the day. You can call and ask questions. They're there to help you, but it's about things that have yet to happen. Okay? If past conduct happened and you violated the law, it already happened. Okay? All right. There's some key statutory definitions. One is immediate family, and that has to do with you can't participate in something which you or a member of your immediate family has a financial interest, or a business in which you have an interest, or you're a trustee or owner. Immediate family is your employees, it's the employee, their spouse, and each of their parents, children, brothers, and sisters. So your let's go back for a second. The employee's wife's brother is immediate family. Your wife's brother, or your husband's brother, is your immediate family. But your sister's husband, or your brother's wife, is not. In-laws, okay? We're talking about in-laws.
We should be out in-laws.
If it's in-laws, not subject to it, okay? All right. A municipal employee is anybody doing anything for the town. You don't have to get paid to be a municipal employee. Volunteers are municipal employees, okay? And just so you know, this law is written broadly. It's meant to apply to everything. So if the law has a choice about how to be interpreted, it's interpreted broadly by the Ethics Commission. An employee is anybody. Not a town meeting member, but we don't have that problem here. Official responsibility, and it says, if you can read it, direct administrative or operating authority, whether intermediate or final, exercisable alone or with others, and whether personal, everything, okay? That's anything that you're going to act on is your official responsibility. Participation, shockingly, is interpreted broadly. If you're sitting at the table saying not a word at a meeting, you're participating. Okay? All right, a particular matter. A particular matter is anything you're asked to act on or anything you're going to talk about. Interpreted broadly. Okay, then we leave the statutory definitions behind and we get to definitions that were really created by the State Ethics Commission and through new regulations. There are several things that says you can't give any person, yourself or any other person, a benefit of $50 or of substantial value, and those words substantial value means $50 or more. There's also a thing called the rule of necessity, and that's if a board can't act because it lacks a quorum due to conflicts. Not because someone was sick or someone stayed home that night or someone's in New Jersey or California or because someone didn't feel like coming. It's only if you lack a quorum because of conflicts of interest. If you lack a quorum because of a conflict of interest, you can invoke the rule of necessity, and everybody who has a conflict may, but need not participate. You can't force someone to participate if they don't want to. So let's say we're dealing with a zoning amendment that's going to affect 3 out of 5 members of the planning board, and the rule of necessity is invoked so the planning board can act, and only 2 of the members choose to act, and you still can't get a quorum because another person chooses to abstain. Too bad, so sad, no recommendation. Okay? You can't force someone to act. But they can, even if it would directly affect their financial interest, which is why you don't want to invoke the rule of necessity unless you know it really applies. You need to talk to the manager before you do that, if you're planning on it, or to your administrator or somebody, your administrative officer, because if you invoke it improperly and it wasn't really available to you, well, then everybody who actually had a conflict has violated the law. Okay? So you need to be careful about using it.
You also must state the particular conflict.
That's right. You state on the record that you're going to invoke the rule, and then the chairperson or the senior person with the conflict says everybody has the same type of conflict, and then each member also has to state for the record what their conflict is, creating a record. And because we just finished the open meeting law, who can tell me if all of that has to go into the minutes? Yes, it does. That's a summary. That's an action taken. That's something that important that happened. Okay, there's also no definition of abutters, but abutters are presumed to have financial interests in any matter, okay, in which they are essentially deemed to be, a person of interest under the Wetland Protection Act or an abutter for purposes of the Zoning Act, and that means property that directly abuts your own, an abutter to an abutter within 300 feet, someone who's directly across the street from you, or if it would otherwise affect your property's value. So if they're going to put a large dump at the end of your street, even if you don't fall into any of those other categories, you're likely to fall into the last one. It's going to affect the value of your property. Now, how do you get out from behind this presumption? You get an appraisal. That's how you get out. Okay? A financial interest. Shockingly, it's not defined, but it has a meaning. And it essentially means it has to be direct and immediate rather than remote and speculative. And it can be large or small, positive or negative. So just because you say, well, this is going to decrease the value of my property, I mean, I'm voting in favor of it. How can you say I have a conflict? Because the law doesn't care. If it's going to affect the value of your property, regardless of how, it's a conflict of interest. It's a financial interest, okay? Okay, who are special municipal employees? This term gets thrown around a lot. Oh, I'm a special municipal employee. You're only a special municipal employee if the Board of Selectmen says you are. And you're only a special municipal employee if you fit into these categories, which is you have to essentially work less than 800 hours a year or be a volunteer. You have to be designated by the board, as I said. You have to, everyone in your board would have to be designated as a special municipal employee. You can't just single out one person, and it's not just the person, it's the position that gets made into a special municipal employee position. Selectmen are special municipal employees in towns of less than 10,000. Yeah.
In towns greater than 10,000, the board has to vote special municipal exemption status
For everyone else.
for everyone else.
But the board won't be specials if there's more than 10,000 residents in a town.
What about an elected official who does work for boards and committees and has to be a special municipal employee?
If the elected official works less than 800 hours a year and fits the other requirements, then they can be designated as a special.
But it has to be by the board.
By the board. But if the elected official does work to carry out their elected duties,
It's not a person, it's a position.
that's a position. That's right. And if they're doing work before other boards to carry out their positions as an elected official, then there's no conflict issue. It's just if they try to do that in their private capacity.
Lauren, does that have to be voted every year, that status, or is it?
No.
No, just
It can be
once.
voted and then it stays until the board undoes it. Every once in a while, towns will revote all of their special municipal employee positions. There should be a list filed with the clerk, and the list also gets filed with the State Ethics Commission. Okay. So, and the law deals with special municipal employees favorably in 2 instances. We'll talk about that in a second. All right, Section 17. So this is where the special municipal employee issue matters in the one instance, and that is that Section 17A says that no municipal employee can receive compensation directly or indirectly from anyone other than the town in a matter in which the town has a direct and substantial interest. I don't need to underscore again that the State Ethics Commission determines things matters that the town has a direct and substantial interest in as pretty much anything the town's going to act on. A court case, a license, any kind of decision, anything that would affect the town that the board is going to act on. Section 17C prohibits a municipal employee from acting as an agent or attorney for anyone other than the town with regard to a particular matter. It doesn't apply to a special municipal employee serving less than 60 days during a consecutive 365-day period. We can talk about what that means after. It's a little complicated. But Section 17 applies less restrictively to special municipal employees. And what it means is that the special municipal employee can appear before any board other than their own on any matter that they haven't acted on already and that they're not going to act on in their official capacity. Okay? And they can get paid for that. All right, there's a recent change, a regulatory exemption for compensation for private employment. There's a bunch of new regulations, and as part of the handouts that you got, you will find that there's a summary of the important new regulations you can read through on your own. But this essentially says that an uncompensated municipal employee who's also employed privately for compensation can get their regular compensation during the time spent serving a public agency without violating 268A. It's a very limited exemption. All right, Section 18. This relates to former municipal employees, and it imposes restrictions on them for life, for acting as an agent or attorney with respect to anything that they participated in. If you wrote some regulations, you can't then go and participate, represent someone else with respect to challenging those regulations. You wrote them. So you're banned for life. And your partners are banned for 1 year for appearing personally before any, for banning for 1 year regarding any activity in which the former municipal employee has a lifetime ban. So you're banned forever, your partner's banned for a whole year. You're also banned for a year from appearing personally before any town board in connection with a particular matter in which the town has that direct and substantial interest, and that was within your responsibility, that you never acted on, but that was within your responsibility. Okay? All right, we can skip forward. Financial interest. This is one of the most important sections, along with Section 20, and this says that you can't participate in a matter in which you have a financial interest or in which your immediate family, business, or employer has a financial interest. There's no special exception for special municipal employees. Okay, this applies to everyone. There are some exemptions. There's exemptions for appointed officials or appointed employees. They can notify their appointing authority in writing of the issues that would create the financial interest and request an exemption. And it is solely within the appointing authority's discretion as to whether to grant that exemption. And they can only grant it if they can decide that their interest is not so substantial to be deemed likely to affect the integrity of the services which the town may expect from the employee. And this kind of goes back to my example I gave where the planning board member, let's just say the planning board's appointed, and they say, I could care less about this. Like, my property is going to be devalued because of this. And I'm fine with it. I'm still going to vote in favor of it. And they could say to to their appointing authority, please grant me this exemption. I'm not going to use this to benefit from my own interest. I don't care that it's going to make my property be less money. I think it's really important my voice be heard on this. And the the appointing authority might say, yes, you're right, we care about that. You see this a lot, like planning directors who also live in town, they might ask for that. If there's a committee that's appointed because people have particular interests in, let's say, the golf course, because they live near the golf course, and so changes at the golf course might then affect the value of their property. But the reason they're on the committee in the first place is to provide a voice about those issues. They might ask for a 19B1 exemption and be granted it. There is no requirement that the appointing authority grant the exemption, but they need to be careful if they grant it for one person that they use a similar rationale for either denying or approving it for another in the same position. They can't use it to discriminate. Not that anyone would intentionally do that, but you don't want to have them make a decision for a wrong reason. It can be for any valid reason. Okay, there's two other exemptions that I'm not going to mention because no one uses them. Well, I'll mention the last one. If there's a determination of general policy that would affect a substantial segment of the population, then even if an elected official has a conflict, they can still participate. But the definition of substantial segment, as interpreted by the Ethics Commission, is 10% of the population, not of the registered voters. So that includes children, and it makes it really hard for that exemption to be applicable. Okay. Recent changes, involvement with nonprofit organizations. a municipal employee who's appointed by his or her board to the board of a nonprofit may participate in matters in which the organization has a financial interest. This is important because, there's times when there's various, interactions between private and public entities. And so particularly, we've seen examples of this lately in the news with the educational collaboratives, where the particular bylaws require an appointment of a member of the public educational collaborative to the private group, and so there's this sharing, and it used to create this conflict of interest problem. So now there's this that tries to help with that. These are relatively new exemptions, though, and so care needs to be taken when you're using them to make sure you fall within the definition. There's also exemptions for the town clerk to allow a town clerk to participate in certain ways in elections where the clerk's name is going to appear on the ballot because, as it must be obvious, if the clerk can't participate in the election process at all, which for years the Ethics Commission went kind of back and forth about how they would interpret that, then who's supposed to run the election? And, if the assistant town clerk works directly for the town clerk, doesn't the assistant town clerk have a conflict? So this is trying to resolve those issues. There's also some precedent that's interesting. The term business organization has been revised lately to include really those matters in which business is being conducted and not just work such as like managing conservation restrictions. So an entity like Trust for Public Land wouldn't be considered wouldn't be considered a business organization. So someone could serve on the Trust for Public Land and the Trust for Public Land could come before the Conservation Commission, and the Conservation Commission member could still sit in on the discussion and vote without violating the law, whereas before they could not. Okay, so let's skip ahead. Section 20 is another important section. We'll go to the next one. Yep. And this is, a regular municipal employee is prohibited from having more than one contract with the town. So if you are a regular municipal employee and you receive compensation, you cannot hold another position with the town where you receive compensation. Adding a second paid contract creates a violation of the conflict of interest law, unless you fall into one of these gazillion-pronged exemptions, which is exemption B, which basically says you have to be working for some other entity in town, not the entity that you already work for, and it has to be outside of your regular hours, and it can't conflict, and they need to have an opening, and they can't fill it with their regular people. So you go through all of that. If you can get to the end of that, then yes, you could get an exemption to hold a second position. Or another option is that you could, if you are, and if you're an elected person, then that's not considered a contract with the town, and you can have a second paid position. Next. What's next? In towns less than 3,500 people, there's an exemption. That's not going to work here. There are exemptions for special municipal employees that don't require the steps I just indicated. Basically, if it's for your own board, then you need the Board of Selectmen to sign off on it and agree that it's okay for you to have the second position with your own board. If it's for another board, you just file a disclosure with the town clerk. Also, there's an exception for selectmen, which allows them to, if they were employees at the time that they were elected, they can continue getting that paycheck. And there's also exceptions for people who I just don't know if I wrote this down here, people who serve in like a part-time fire, police, or emergency position. There's exceptions for people who might receive housing aid or rental assistance from the town that allow them to receive that additional benefit just by, without violating this section, just by filing a disclosure. So if you have a question like this, a second paid contract with the town, whether it's a second position or you're going to provide paper supplies or something like that, you need to see if an exemption is available to you. And you can also resign from one position, and that cures your problem as well. There's an exception, a new exception for conveying property to a municipality, eminent domain. If the town takes your land, it's not considered to be a conflict. You can participate in the senior tax abatement program. Section 21A says that if you're going to be appointed by your own board to a position under your own board, then town meeting has to approve it. And town meeting sets the salary. So
If it's elected or appointed?
if the board, let's just take the school committee for a second. If the school committee is the appointing authority, the school committee cannot appoint the superintendent from among its membership unless town meeting authorizes that ahead of time. okay, and sets the salary. And the idea is that somebody else should keep an eye on that. And the State Ethics Commission has said in the past that town meeting should actually specify the name, and we've argued with them about that and said, well, sometimes, like Board of Health, this comes up a lot, like a single member of the Board of Health wants to act as the agent or with the assessors, and, we say ahead of time, they don't know who, one, who's going to be elected or appointed, and two, who's actually going to want to wind up doing it once they see what the full complement is. So just the authorization is good enough. All right, and then the last thing that's important to know about is the code of conduct, and that's under Section 23. One important thing is that you cannot participate, you cannot give anyone a privilege or benefit that wouldn't be available to anyone else in that position if it's worth $50 or more. That $50 or more thing matters. For example, you can't, you couldn't get someone like the opportunity to file for a senior tax abatement if that opportunity isn't available to anyone else. It's worth $50 or more. You can't put that person at the head of the line. That's a violation of Section 23B, and there is no exception for that, B2. Section 23B3 is something you hear about a lot, and that would be the appearance section. If it appears to someone that you have a conflict, even though you don't, you should file a disclosure. So let's say your best friend is an applicant. I mean, you might not want to participate at all, but you're not prohibited from participating under the law. What you would have to do, though, before you acted is file a disclosure under 23B3. That would be with your appointing authority if you're appointed, or with the town clerk if you're elected. And you'd put right in there, so-and-so has lived across the street from me for my entire life, but I believe that I'm capable of reviewing the facts applicable to this application, regardless of my personal relationship and in accordance with the laws and regulations that are the facts, laws, and regulations. As soon as you file that, it's unreasonable for someone to conclude that you're acting based on your relationship and not on the law. But you have to do it before you act, okay? If you're elected, good thing to file it with the clerk and make a statement on the record. If you're appointed, file it with your appointing authority. And, if you're trying to go the extra mile, stay it on the record as well. It's good, especially if you're at a hearing where you're adjudicating someone's rights, because it raises due process issues. So the more information in the record about your objectivity, the better. Say it for the record as well. There are new regulations under the conflict of interest law, and the law was actually revised as well. Fines have increased for various violations. Okay, we can go to the next one. Penalties under 17, 18, 19, and 20, up to $10,000 or 5 years in prison. This is not something to fool around with. Section 21 allows the State Ethics Commission to order restitution of up to $25,000 after an administrative adjudicatory hearing. The State Ethics Commission can rescind or cancel action that's taken by a municipality if it determines after a hearing that violation of law substantially influenced the action taken by the municipality. So this is similar to the court, the statute that authorizes a court to do this. It's the same statute, and what you need to think about is that you want to protect your decisions. So if a chair is very concerned about a conflict, see if you can put something off. Continue that hearing. If it's a public hearing, you're going to continue the hearing to a time, date, and place at least the 48 hours after the posting. Otherwise, you'd have to renotice. Notice under whatever hearing statute might be applicable. There's minimum levels of training, as I know you all know about. There's amendments to various sections that were changed by regulation. There's a lot of exemptions related to gifts, so that's especially important for teachers. It really changed the rule. Basically, teachers can aggregate presents up to $150. So if you get presents from a class, it can only be up to $150 for teachers. They can still get individual presents up to $50. So that's important for people to know when it comes to the end of the year. This substantial value thing I told you about before is now codified in the regulations as the $50. If we just go back for 1 second. Notice it says calculated by determining fair market value or face value, whichever is greater. This idea of free tickets, there was like a lot of that when the Red Sox were in the World Series or the Patriots in the Super Bowl. Tickets will be viewed by how much they'd actually be worth, not just what they say in them. So, if you have an opportunity or, as a result of your position to do something, you need to think carefully about whether it might violate the law against gifts, because the Ethics Commission will deem it to be a gift if it's worth more than $50. And then that would violate the law. If it's given to you for or because of official action. If it's given to you because the person's your best friend, then that's outside of the ethics law. Okay. Okay. Teachers I already told you about. Travel. If you're going to travel for public business now, the law allows you to receive the money to pay for that. It used to be that you couldn't get paid for that, or you'd have to go through this kind of convoluted procedure, and now there's a much clearer process related to that, and it's set forth in detail in the regulations. This is just my warning. Before, ask before. Better to ask before. I think I said that 3 times. I can say it one more. Ask before. We are in a much better position as a group. The town is in a better position if you are paying attention to your conflict issues. And if something happens, you get to a meeting and someone's sitting in front of you who you have business dealings with, or you're in the process of buying a house with, or anything like that, just pause. If you are feeling like, oh, that's great, so-and-so's here, that's something for you to think about. Oh, is that so-and-so? Is that something I need to disclose? Or is it something that's going to prohibit me from participation altogether? And if you need time to figure it out, better to say for the record, I may have a relationship with that individual that I'm concerned about, and therefore I'd like the opportunity to look into my conflict issue before we move forward, and I'd ask that, the applicant agree to a continuance. And something like that, if you're the chairperson, or talk, could we have 5 minutes to discuss the conflict issue before we move into the substantive issue? All right, I thank you all very much, and I'm sorry for the confusion with the outlines, but you do have everything you need in there, and the State Ethics Commission also has a very helpful website with a lot of information, and it actually provides information by topic and by position, so you can search both, and I have a link to the website here as well in case you need it. Thank you very much.
Thank you. Thank you. Thank you.
Let's take a 3-minute recess while they break down.
Really?
Without further ado, it's 6:50. I'd like to call this meeting of the Abington Board of Selectmen to order. Would you please rise and join us in the Pledge of Allegiance and remain standing for our first public announcement? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, at this time, in honor of all the innocent people that lost their lives on September 11th, 2001, would you please join the board in a moment of silence? Okay, thank you. Please be seated. Okay. Public announcements. Tomorrow night, September 13th, at the Council on Aging, our State Senator Keenan will be holding a town hall meeting to discuss the casino bill. That's at the Council on Aging tomorrow night at 7 p.m. And also on September 19th, from 10 a.m. to 4 p.m. will be the 31st annual Fall and Christmas Craft Fair to raise money for Abington Music Parents. Again, that's going to be held at September 19th at the Abington High School gym from 10 a.m. to 4 p.m. Also, the 10th annual September 18, 2011, 9 a.m. Jeff Coombs Memorial Road Race Walk and Family Day. It's the 10th, and it's on September 18th, 2011, 9 a.m. It's going to be a 5K walk or run, and I guess you can register that morning.
Yeah, you can sign it.
Okay. Does anybody else have any public announcements they'd like to throw at me? No. Okay. Alrighty. Okay, first on the agenda is an application for a flammable storage license at 538 Bedford Street. The Town of Abington will hold a public hearing on Monday, September 12, 2011, at 6:35 p.m. in the Carter Hearing Room, Town Hall, 500 Glenowicz Way, on the application of Tedeschi Food Shops and Burger Time Realty Trust. Roger P. Woods Jr., trustee and owner of land, 538 Bedford Street, for a flammable storage license consisting of two 20,000 two-compartment tanks, with each tank, one 12,000-gallon compartment holds regular gasoline. In one tank, the remaining 8,000-gallon tank holds premium gasoline, and in the other, diesel fuel. Okay, I'll entertain a motion to open the hearing.
Mr. Chairman, I'd like to recuse myself because I have a business relationship with the petitioner.
Okay, Selectman Franny recuses himself. I'll entertain a motion to open the hearing.
Make a motion to open the hearing.
Okay,
Second.
second. All in favor?
Aye.
Okay, the hearing is now open. Is there anybody here tonight to speak to this?
Yes, Mr. Chairman. Good evening. My name is Jack O'Leary. I'm with Merrill Associates of Hanover, and I'm here on behalf of Tedeschi Food Shops and Burger Time Realty Trust to request that you grant a flammable storage license for the property at 538 Bedford Street. Before we start, we did notify abutters as required by law, and I do have those green cards that were returned, along with the other ones that didn't come out. Also, this hearing was noticed in the Brockton Enterprise, and we verified that the ad did run a week ago, according to the law. I have with me Bob McGann of Tedeschi Food Shops, and I'd like to give you just a brief overview of the project and before we request the license. The project is located at 538 Bedford Street at the intersection of Glenowicz Way. It is owned by Burger Time Realty Trust, and Tedeschi Food Shops is planning on constructing a convenience store and self-serve fueling facility at this location. The project it's in the highway commercial business zone, and the project has been reviewed and approved by the Abington Zoning Board of Appeals and by the Abington Planning Board over the last 9 months or so. And since it does include a fueling facility component, we do require underground storage tanks, which in turn require a license from your board. We did receive submit an application as required under Chapter 148 for that license, and we did receive a favorable letter from the fire department upon review of that application, which I'd like to submit for your review right now. So as described in the application, the proposal is to install 2 underground storage tanks. The total volume in each storage tank would be 20,000 gallons, and they would be divided, as you described in the advertisement, so that one compartment 8,000 gallons and the other compartment 12,000 gallons. And one of the compartments will be a diesel tank, and the other compartment would be a regular gas in that tank. The other tank would have a regular compartment and a premium compartment, and the proposed dispensers would blend the gasoline grades to obtain the mid-grade product that would be sold at the customer's option. Each of these tanks will be double-wall fiberglass, will have continuous interstitial monitoring. The product piping to the tanks will be double-wall fiberglass as well. There will be containment sumps located at all the critical areas at the fills of the tanks, beneath the dispensers, and also in the, those are the locations where the fills will be placed. The tanks, of course, are heavily regulated. The EPA and the DEP have been in this business for many years, and the tanks will be meeting all of their requirements. There are many features of these tanks that make them safe, which we can discuss at length if you have any questions. And that's really about it. What I just want to emphasize one point is the diesel fuel is really being offered as a convenience to the local contracting community, and the town, if the town's vehicles need diesel. This is a standard passenger car type dispenser with a small diameter hose. It is not intended to serve diesel trucks, and a diesel truck is typically looking to be, it takes a lot of fuel, and these small passenger car hoses just can't deliver it at the rates they're expecting. So that's an important point to note. There is one truck that will access the site, which is the fuel delivery truck, and we've designed the site such that the tanks are located by Bedford Street so that the tanker truck can access the site entirely from the Bedford Street driveway if it so chooses. However, some discussion of that came up during the planning board process, and the fire chief and the police chief had been granted the ability through the planning board's approval to review the tanker deliveries should any tankers access the site in a way that they feel could be improved. The tanker deliveries are restricted from between 9 p.m. and 6 a.m. so that the deliveries will not occur during the peak traffic hours of the surrounding roadways and uses. So with that, we'd like to request that you grant a flammable storage license for a total of 40,000 gallons of underground storage. And if I can answer any questions, I'd be happy to do so.
Does the board have any questions?
Yeah, Mr. Chairman, if you could, would you read into the record, and you've provided us with plot plans, but I think for the purposes of spreading upon the record, would you articulate where the gasoline pump stations will in fact be?
Oh, the dispensers?
Yes.
The dispensers will be between the building and Bedford Street. The building faces Bedford Street, and so the dispensers are located between the building and Bedford Street, and they're perpendicular to Bedford Street, and they're intended to be primarily visited by traffic from Bedford Street, from the existing curb cut on Bedford Street.
And how many dispensers will there be?
There are 3 dispensers proposed. 2 will be gasoline only. One will be a gasoline that can also gasoline dispenser that can also dispense diesel.
Thank you.
So the 3 dispensaries would have 6 filling spots?
6 fueling positions, yes. So there could be 6 cars fueling at once.
Any other questions from the board?
And as far as the tanker deliveries, you said it was restricted from 9 p.m. to 6 a.m.? Who put that restriction on?
That is a restriction that was agreed to with the planning board, and it's in the planning board's site plan review decision, which I have a copy of if you want that for the record.
This is a land lease, correct?
Yes, the land will continue to be owned by Burger Time Realty Trust, and it will be leased with an option to buy to Tedeschi Food Shops.
You know, I took notice in the packet, usually when we do a license transfer of most types, there's a copy of the lease with the information. There was no copy of the lease.
If that's something you require, we can provide that.
Does anyone have a copy of the lease?
The license runs with the land, so that's why there's no copy of the lease itself. Mr. Woods will own the license, not the tenant. So whether the tenant changes or not, the license is there. It actually, so for the record, we let it submit a copy of the lease. There's also an option to purchase the property, so it may be in the future that Tedeschi Food Shops or one of their entities will own the property at some point.
Any other questions from the board?
I guess my question is, being new at this, is what grounds can we deny this or approve it? I mean, I have no expertise in, oil tanks and gas tanks. I mean, we've got a letter from the fire chief saying that it's okay, and I know we have to sign off on it, but I mean, is it just like, yeah, it's a good idea, let's do it, or no, it's a bad idea, or it's unsafe? I mean, I'm not an expert, so how does the Board of Selectmen decide?
Just as a rule of thumb, these licenses are either renewed or changed upon ownership. This is a new license. You can discuss the safety of the 40,000-gallon tank in relationship to the proximity to the neighborhood. How many Tedeschis have blown up over the term of that Tedeschi fueling depots or pumping stations have really violated the public safety in any way, shape, or form. And you look at the track record of Tedeschi, you look at the design of the pumps, that's all been done for you through the fire department. They have determined that they're safe, they're built to compliance, like any other fueling depot of similar storage capacity. And again, you ask yourself, how many of these tanks have blown up over the last 10 years, 5 years, or what have you, and they're really designed by CMR and by specifications at the state and at the local level.
So basically what you're saying is our vote is just on the tanks itself, nothing else concerning the property, the way the road dumps into Glenwood's Way, none of that?
That's correct.
Any other questions? Before I open it up to the floor, I just want to remind everyone that we're here to discuss the tanks in the hearing. We're really not here to discuss prior variances or any planning issues. Would anyone from the floor like to speak to this matter? Yes, sir. Could you please come to the podium, grab that microphone on the way up? Please. Yes. We require all speakers to state their name and address.
My name is John Shepard. I've been in the petroleum business for over 30 years, primarily responsible for gasoline. Guys that own their own stations very often go in front of boards like we are now. This is the first time I've been really beat up.
Could I just introduce you? Interrupt you. Could you just state your address?
560 Bedford Street. I'm in a butter.
Thank you.
And anyway, having said all that, I just heard a few things that I need to clarify one thing. How much notice were we supposed to get for this meeting? Because the reason I say that, we were notified after the mail was delivered on Saturday. The mail was delivered with a little green thing saying go down and pick it up at the post office. Now, when that day came, which is actually Tuesday because of the long holiday, so therefore people that work and whatever can't make it tonight because some people couldn't get the time. That's a question I have here. Now, I also heard mentioned just now, the license. There was no mention about a drive-through coffee, too. And again, you're saying, what does this have to do with tanks? It will have something to do if there's any kind of population density at the location, if there's any kind of fire or explosion. Now, it doesn't have to just be tank explosion. There is tank explosion from cars. There's tank explosions from the lines, and that is a very critical condition. And I bring that point up because where we live on Route 18, it has happened numerous times where there has been line leaks for the natural gas going through there. When we called the people in town or at the natural gas people, they would come and say, and if you've seen all the digging up they've done, they'd go one section at a time, and we'd still smell fumes in our buildings, which we have. A lot of our buildings now are getting water, which we never had. So we do have cracks in ours, because we are basically on wetlands itself. It was approved by town politics years ago, but we are now going to be suffering the outcome of this situation. Now, I don't mean to jump here. I'm very nervous because I am retired, and this is the last thing I ever thought would ever happen to me. Now, driver, what I wanted to say is about the night deliveries. The town of Athol, Mass., for example, will not allow night deliveries. You say why? Because the way Tedeschi's is, here's how it usually works. When my company would say, well, you go check out a piece of real estate and see what you think and all that, I would go there, speak with a realtor, and the realtor would say, yeah, I got this. And then I say, well, can you get the permits? Yeah, I can get them. 99% of the time, they're not going to get the permits because we're not going to waste our time. And secondly, you don't buy a gas station before the pumps. So you lease it with the option to buy. You're not investing. They're going to be investing, in my opinion, close to $2 million for this whole deal. And that's the tanks. Another thing. I heard here the fire chief approved the $40,000. He had no problem with the 40. I disagree with it. because 40,000 on a small footprint's called. You're on raw land, never had gas. Now, any problems that exist in the future, they belong to Abington. They belong to us, and I can give you an example, Ashby, Mass. It's on ledge, like here. 20 years later, they're still trying to remediate it. So what? As Mr. Smith in the meeting told us, don't worry about it, they'll fix it. Well, try to fix something 20 years down the road. How do we sell our locations? If there is a leak or the leak, if there is one, gets in the lines, and there's any catastrophic regarding from natural gas or the gasoline going into our buildings, that is my concern and all of our people here. Now, I also heard there's absolutely safe about gasoline tanks. I called a former customer and a president of, he has been on the state Superfund for well over 10 years, Thomas J. Porter. And this is open information, but he gave it to me. He said, John, if there was no claims or no problems with the gasoline tanks, then why are we still in existence? These new double-wall tanks, interstitial line with all the bells and whistles, the lines go off, they do go off, and guess what happens? They don't listen a lot of times. And I'll give you an example. The company I work for, Peterborough Oil, in Leominster, Mass., a line leak went off. It went to their office. The guy wasn't in the office. A lot of times the alarms are in the back room or something like that, or the employee doesn't know it's about. Guess what? Over 7,000 gallons were dumped in the ground. And it's a truck area too, so the danger there was unbelievable. And again, this is extremely commercial, so the effect really is only from a blowing up standpoint. And again, now, Mr. Porter told me there is 100 claims per month. On average. There is the state, how a Superfund works, $25 million goes out approximately from the state, even though we all pay 2.5 cents per gallon. Other 2.5 cents, the state puts that in the Superfund and then allocates X amount of money. They take in about $75 to $80 million, of which 25 million usually goes to the state. To the state Superfund. Right now, there is over 1,700 unprocessed claims. That's my question. And that's because they have line leaks, and that is your big fear. It's not the tank so much blowing up, it's the line leaks. Now, the company that handles it, Sedwich, quit because there's no money right now from the state. And they're not making any money, so they're not going to be monitoring the program. So right now, the DEP is taking that over on an interim basis until they can find someone else. Okay, a good example. This never happens, right? Honeydew, Worcester, Massachusetts, right now submitted their first claim for $165,000 because they had a very simple thing. You say, and this is stage 2, which is the vapors that is coming back to the tank or through the vents. You see those vent pipes at gas stations. Now, talk about any kind of fumes at night like that, or with your night deliveries, especially with fog or anything like that, you're just waiting for a disaster. But now, this has happened to Honeydew. This is already in the process. He said the average location submits 20 claims. It's not. You start in phases of remediation. So this isn't going to happen overnight. Again, who suffers but us? And actually, the town will too, because now the fire department's going to get involved in all of that. And I got to go back here. When you mentioned the fire department, I spoke to him. He wasn't against the gasoline tank per se. I am. I think it's an absurd amount. And diesel was never mentioned before. And they're going to have problems with mixing gas and diesel, but that's their problem. But tanker trucks will still try to go in there unless you have some giant signs that do not go in there. Because if you ever look at canopies, a lot of them have dents in them. And that's for guys with these 14-foot trailers, and they don't read them, even though you got a sign up there that says 14 feet or 14.5 is usually numbers that they'll put in there. It happens. And again, what are you just waiting for a problem? Now, again, I'm going to miss some stuff here because I think this is so important. The fire chief, this is what I wanted to get at. Mr. Rangel over here in one of our meetings brought up the point about fire getting in and out, his equipment and all that. The fire chief said he was against it. He sent a 2-page letter saying he was against the project as proposed because of the building. He couldn't get his equipment in and out. So if we have an explosion or anything of that nature, how does his equipment come? Okay, so what? It won't happen. Again, I think I proved myself here that this stuff does happen. Over 1,700 claims. I'm not saying explosions, but tank leaks or line leaks is your biggest enemy in the business. Those are the things that get in lines or goes with other product or whatever, follows a line, gets in your house, and God forbid you light a cigarette or have propane or whatever you got in your house or on your back porch, boom. Ask the people in Peabody right now, they're going through that process trying to figure out how it started. But just so I'm not being taking this out of context here, I want to give you what Mr. Rainbow handed out to our meeting and the fire chief. I mean, just to tell you about the fire, not just the top part. I'm not trying to make this long and laborious. But again, getting back to the fire is probably if you can't get the equipment on there, if you do have an explosion or anything, and very often you have those leaks or whatever, is the driver on a rainy night isn't paying attention, and they have what they call drop tools or whatever that shut off automatic, so-called automatic, but if they're not checked and monitored, which they're supposed to be done, now it's every 3 years the federal government's required the state of Massachusetts to do that. And that's an area that I really pride myself in knowing the laws for my customers. So the concern there is the leaks that would cause the explosion. And that's aside, I shouldn't say anything about him next door. He was very upset. My concern, again, I will not continue on more than this, but it's the static electricity is another big issue that you can have from these locations. And two things. One is the cell phone user. Boom, you can cause the fire and explosion right there. All of this can go back to the tanks with the lines and all this. That is the key, and they say they got shutoffs and all that. They do have petcocks and all of this stuff. They do not necessarily stop it. And there has been fires to that going back to the tanks. The other thing is women are probably the worst causes of static electricity because when they get out of their car, they do not touch the side of their doors or whatever to demagnetize themselves because they're afraid to get their clothes dirty. Shell oil, mobile oil, I've helped sell many years as a distributor, have sent out notification every year to their people to be aware of this and inform your public and your customers that they could cause a tank blow up or your car blow up. And it happens. It happens a lot more than you think it does. Again, that's about it. My wife would like to speak after that because she's done a lot of research on explosion. But I do want you to reinforce the fact that the state DEP, which is this information is available on the Superfund. Thomas J. Porter, there's the guy from right here in Brockton who's on the board at Mutual Oil Company, very influential in the laws. Another one, Brayley Wellington, who's in charge of the tank insurance. You can get private tank insurance, but I didn't mean to bore you over there.
No.
Any questions?
Do you have any questions?
I just said, Mr. Chairman, through you, it says in the statute or the bylaw that the abutters must receive by registered mail not less than 7 days prior to such hearing.
Can we take a look at the... Can we
Yep.
take a look at it, please? Can we take a look at it?
My concern is that I'd hate to have to do this again. That's, if they did not receive notice.
So they got them on the 2nd.
No, can I interject? It was from Merrill's September 2nd. Does that count?
Postmark.
Yeah, but Merrill did it out of Hanover. It's their own stamp machine. That's metered machine. Okay?
came back.
Can we take a look at them, John?
Christopher.
Yeah, if you don't mind, John, could you just give us a stack, Wes? Thumb drive? Thank you. Ma'am?
Okay, I just want to explain a little bit, because he brought up a good point, was the claims from the DEP, these are for claims that people have had gas leaks have not been resolved yet. They make claims in the ongoing process, and it takes, on average, 20 claims. God forbid there were one here. 20 wouldn't even begin to count what they would do. That's providing the state would even have the money available at the time